Hi, I'm Suzanne and I'm going to talk to you about terms and conditions. We've all done it and we know we shouldn't, but it's an especially dangerous practice to sign up to terms and conditions without reading them on behalf of your business. Here's a quick guide to seeking out the really important terms with which your company will need to get comfortable and to ensure that you know what's expected of your business and what risks the business is taking on by agreeing to the terms and conditions. Firstly, payment terms. How are you expected to pay and how often? Are the costs fixed or is there provision for additional charges? Do you have a checking process in place to ensure that these costs do not spiral out of control? Are there late payment terms and are the interest rates harsh? If so, you'll really want your account system and cash flows to be reliable. Secondly, the big one, indemnities. Indemnities are included in contracts to make it very clear who has to pay when things go wrong. Indemnities are often included by the party who has the most negotiating power, i.e. the party providing the terms and conditions, and often on a take-it-or-leave-it basis. These are also often drafted broadly. A standard broad indemnity might look something like, you indemnify us for all the costs, losses and damage incurred as a result of this contract. Even if a business you wish to deal with states that its terms and conditions are non-negotiable, it's worth checking their indemnity and seeking to strike it out or at least include a standard carve-out if possible. The standard carve-out you can expect to see is, except in the case of fraud, negligence or willful default. Without this carve-out, the other side can act absolutely appallingly in relation to your agreement and can still call on you to cover the resulting losses. Check carefully to see what acts your business is guaranteeing under the contract and check whether you can be truly confident that these acts either will happen or you're happy to bear the cost of them not happening. A contract might also seek a guarantor for your company. Be careful when bringing third-party guarantors into your business. If your business fails, your guarantor's liability will carry on beyond the winding up of your business entity. Termination. Can your business get out of the contract if and when it needs to? And can your business afford for the contract to be terminated by the other side? Notice provisions are often negotiable. If you think you would need 3 months' notice to replace a supplier with an alternative, then make sure you ask for it. If there are terms in the contract which are essential to the contract being of worth to you, for example, minimum deliverables from the other side, then make sure you have termination rights attached to those things. If you only have an ability to claim for monetary compensation, this might not be enough to deal with the damage a supplier or contractor's failure is doing to your business. If you're unsure of what rights you have in a set of T&Cs, a quick email to Virtual Legal can often help clarify. Mediation, arbitration, dispute resolution. When things go sour in a business, it's very satisfying to say, I'll see you in court. But often alternative dispute resolution offers a faster, cheaper, and sometimes more cooperative method for solving problems. Check your T&Cs for these clauses because they will usually operate to the exclusion of the courts, and you want to be sure that you would be happy that the method, venue, and person resolving the issue are appropriate and fair. Terms and conditions have gone to court a lot. Often they're written in fine print, waved in your direction briefly, or written on the back of forms. Do look at them, do assume they will be contractually binding, and do negotiate them if you need to. And do ask Virtual Legal if you need a hand.